The contract documents. What is FIDIC Rainbow? The FIDIC Red Book construction is a contract form where the design is made by the employer and the contractor is paid on a measurement basis. Thus, the Red Book follows the traditional procurement route of design, bid and build. The accepted contract amount is based on estimated quantities. The contractor is paid for the actual quantities of work he carried out. The second type, the FIDIC Yellow Book plant, is a contract form where the design is carried out by the contractor who shall be paid on lump sum basis. It is considered to be a well-balanced contract form holding a fair balance between the interests of both parties to the contract. The FIDIC Silver Book Turnkey is a contract form where the design is carried out by the contractor who shall be paid on a lump sum basis, but the Silver Book is envisaged for EPC turnkey projects and allocates most of the common risk to the contractor. It is not intended for use where major identified risks are presumed or expected. The FIDIC Green Book short form is intended for relatively small projects or works of a repetitive nature or short duration. The works are to be carried out according to the design provided by the employer. FIDIC's guidance suggests that $500,000 and 6 months should be regarded as reasonable limits on the capital value and duration respectively. The FIDIC Design Build and Operate form, also referred to as Gold Book, is a design and build contract form to which an operation and maintenance period has been added. The FIDIC form of contract for dredging and reclamation works are referred to as the Blue Book, has been published in 2006. The most essential part of a Blue Book contract is the description of the activity itself, the specifications, drawings, and design of the work. The nature of dredging and reclamation works typically requires major dredging equipment, thus there is a need for a particular risk allocation in order to protect the contractor in the event of any additional mobilization of such equipment. Why FIDIC books are well-known and recognized form of contract. The reason for this is that all contract forms provide, number one, rules for the adaptation of the agreed contract amount, rules for extension of time for completion variation procedures. Thus, all contract forms, depending on their purpose in a major or less extensive way, are flexible management tools requiring experienced and skillful staff working on behalf of not only the contract and employer, but also the engineer. Moreover, as to the engineer, the contract forms requires an independent and impartial person. FIDIC form contract recognizes that the successful completion of the project is a process which cannot be totally planned at an early stage, although there required great skill and care at pre-tender and tender stage. FIDIC strongly recommends that the complete design or the employer's requirement shall be prepared by experienced engineers and architects in order to ensure that the intended purpose will be achieved and realized. The contractor, on the other side, is to scrutinize the design or the requirements before submitting his tender. Although all these precautions are provided, no project can be realized on a green disk and under academic or perfect conditions. A lot of things may change or happen, having an effect on the time for completion and the contract daily work of both parties to the contract and the engineer. FIDIC Books dispose of a large arsenal of mechanisms such as instruction and variations, claims, suspensions, orders, proposals for variations, design changes. We have general observations as to the FIDIC contract documents. This is illustrated in the next points. All FIDIC books refers to divisions. Most the definitions are those which are listed in clause 1. However, the parties will also find definitions in other documents and even outside the contract. For example, some of FIDIC clauses refer to the base date, which is defined in the subclause 1.1.3.1 as being the date 28 days before the latest date for the submission of the tender. Some further definitions depend on the letter of tender, some on the letter of acceptance or the contract agreement, and some on other contract documents such as the specifications and the schedules. The parties must also be aware of the fact that the general conditions contain so-called fallback clauses which need to be given effect by the parties. Care has therefore to be taken when completing the appendix to tender. Additionally, subclause 13.6 will only apply if a day work schedule has been included in the documents, although subclause 13.8 only applies if the adjustment data have been included in the appendix to tender. If parties fail to complete those data which are necessary for application of fallback clauses, those clauses will not apply. One of the most critical contract documents are the particular conditions, especially if they set aside provisions contained in the general conditions, and if they amend them. It is often the case that parties who are not familiar with the FIDIC risk allocation approach, the main FIDIC concepts, the underlying or governing law, the techniques on how to change and amend the FIDIC documents fail to put together a clear contract which is free from ambiguities and discrepancies. It is, however, critical for a contract to be clear and free from ambiguities and discrepancies. The clearer the contract is, the greater will be the parties' incentive to avoid or mitigate non-performance and disputes. If a contract is unclear, it will be very difficult to make rational decisions about avoiding or mitigating risks. Determine the applicable law and check the meaning of any terms and expression in this context. Avoid using and terms which are being translated into English without having cross-check their legal meaning. Beware that FIDIC has adopted a number of Anglo-Saxon concepts such as the principle of time at large, delay or liquidated damages, substantial performance engineer. Remember that FIDIC defines many terms which are capitalized, and that a correct and careful application of defined terms is critical in order to avoid misunderstanding, ambiguities, and discrepancies. Be aware that FIDIC documents incorporate many cross-references, thus the deletion of a subclause may lead to complicated and time-consuming disputes. For example, in Eastern Europe, contractors encounter the problem that quite often subclause 20.2 to subclause 20.4 has been deleted without having changed subclause 20.6. However, subclause 20.6 presupposes that a DAB has decided upon the dispute before the dispute can be referred to arbitration. FIDIC forms of contract are viewed as manuals that provide details of contract management tools. The books contain mechanisms for prescribing and controlling the behavior of the parties. In particular, they require compliance with the reporting. We need to see subclause 4.21 and communications rule see subclause 1.3. The programming requirements see subclause 8.3 and the claim procedures see subclauses 3.5, 2.5 and 20.1. Reviewing and altering a FIDIC basis contract means therefore not only to have a look on risk allocation rules and the obligations of the parties, but also on the management tools. Be aware that the alteration of management rules may change the whole contractual system and can lead to unreasonable results. This will be the case if the particular condition provide additional claims of the employer without references to subclause 2.5. Failure to do so may allow the employer to withhold payments beyond the payment certificates which are issued by the engineer. If we need to illustrate contract documents book by book, Red Book, assuming the traditional procurement route with the FIDIC Red Book 1991 edition standard form of contract and a bill of quantities in the contract documents in order of importance are as follows: the contract agreement, if any, the letter of acceptance, the letter of tender, the particular condition, these general condition, the specification, the drawings, the schedules, and any other documents forming part of the contract. And we illustrate this in particular in the right part. For the Green Book, assuming the traditional procurement route with FIDIC Green Book standard form of contract, then the contract documents in order to importance are as follows: the agreement, particular condition, general condition, the specification, the drawings, the contractor's standard design, the bill of quantities. For Yellow Book, assuming the design and the build procurement route with the FIDIC Yellow Book, the contract agreement, if any, the letter of acceptance, the letter of tender, the particular condition, these general conditions, the employer's requirement, the schedules, the contractor's proposal, and any other document forming part of the contract. In Yellow Book, we see the employer requirements as one of the document for Yellow Book. However, in accordance with subclause 1.5, the so-called proposal, even though it has been developed from the employer's requirements, has lower priority than the requirements. Thus, in the event that the contractor's proposal includes details which deviate from the requirements, the contractor must follow the requirements instead of the proposal. If the contractor intends to follow his proposal, he must firstly request an instruction from the engineer, who has the power to change the priority of document, as it is suggested that an instruction which changes the priority of the contractual document in a way that a document of lower priority overrules a document of higher priority constitutes a variation. The engineer must carefully consider the consequences of such an instruction, in particular if he is under the duty to obtain prior approval from the employer for any instructions which have an impact on the contract price. For the Silver Book, assuming the design and build procurement route with the FIDIC Silver Book. In this edition, standard form of contract and employer's requirements in the contract documents in order of importance are as follows: the contract agreement, the particular conditions, these general conditions, the employer requirements, the tender, and any other document forming part of the contract. In the Silver Book, the contract agreement, as referred to subclause 1.6 and being the main document under a Silver Book contract, represents, subject to the governing law, the legal binding agreement between the parties, which refer to all the documents which are incorporated into the contract. There is in principle no letter of acceptance. The related definition has been deleted in the Silver Book. The term preliminary design is not defined, thus the question arises as to what is meant by preliminary design. Sure, it has to be developed from the employer requirement. The issue is that there is no clear definition of what is meant by employer's requirement. In essence, the requirements set out what is the employer requires from the contractor. According to subclause 1.1.1.3, the employer requirement specifies the purpose, scope, and or design and or other technical criteria for the works. The FIDIC Contractor's Guide explains that the overall design may comprise three stages: the conceptual design incorporated in the employer requirements, the preliminary design incorporated in the proposal, and the final design to be made once the contract has been awarded. Hence, in principle, the employer requirements should describe the principal and basic design of the project on functional basis and specify the purpose, scope, and or design and or other technical criteria for the works. However, as already mentioned for the Yellow Book, it could be said that the employer requirement do not define the particular works which have to be carried out by the contractor, because this document specifies only the purpose, scope, and or design and or other technical criteria for the works. Making use of the Silver Book requires an acceptance of a special risk allocation concept, which requires both discipline and instinct from the draftman's. FIDIC points out that the conditions of contract for EPC turnkey projects, the Silver Book, are not suitable for use in the following circumstances: if there is insufficient time or information for tenders to scrutinize and check the employer requirements, or for them to carry out their designs, risk assessment, studies, and estimating, taking particular account of subclauses 4.12 and 5.1. If construction will involve substantial work underground or work in other areas which tenderers cannot inspect, if the employer intends to supervise closely or control the contractor's work or to review most of the construction work drawings, if the amount of each interim payment is to be determined by an official or other intermediary, in the event of doubt, the parties are advised to use the Yellow Book, which is a more balanced contract form, although also requiring a substantial amount of skill and care from the contractor at pre-tender stage. For contract document manual, we have contract agreement. We have the particular conditions. The particular conditions shall cover all project details and particulars, including any modifications of the general conditions except those to be specified in the appendix to tender. Under a silver book contract, all details otherwise contained in the appendix to tender must be covered by the particular condition. The silver book comprises a guidance for the preparation of particular conditions to which reference to made. However, most of the data included in the appendix to tender of the Yellow Book form must also be inserted in the particular conditions of a silver book contract as there are. Some of the above-mentioned items are optional, such as changes to subclause 3.5 or subclause 20.1. Some of them require data because otherwise the related subclause will not apply. Under a red or yellow book contract where specific project details are specified in the appendix to tender, or under a gold book contract where such details are specified in the contract data. Particular conditions may be used for adjustment for the general conditions if appropriate or necessary. Also, we have employers' requirement. This for the silver book, yellow book, gold book. Both the yellow book and the silver book follow the second rule. The silver book guidance for the preparation of particular conditions, as well as the yellow book guidance, clearly indicates that the employer's requirement should specify the particular conditions for the completed work on a functional basis, including a detailed requirement on quality and scope. Thank you.